So good morning, everyone, and thank you for joining us for today's webinar on changes to prompt payment legislation with the Ministry of SaskBuilds and Procurement. My name is Adam Brome, and I am an Administrative Coordinator with SARM. As always, we will start off today's webinar with a brief introduction to the Adobe Connect platform. We will then transition into the main presentation, followed by a Q&A session. This webinar will be recorded, and a copy of that recording will be available on our website on the webinars page. To maximize your audio and video during today's session, please join us through Google Chrome or the Adobe Connect desktop app. If you're joining us on a mobile device, please download the mobile app for a better experience. The chat box is located on the right side of the webinar window and is visible to all webinar participants and facilitators. You can use this to connect with other attendees, inform us of any technical difficulties you may be having, or to provide any other general comments and/or feedback. There is a dedicated question and answer box labeled Q&A, which is located right underneath the chat box. This is where you can submit any questions that you may have regarding the webinar content throughout today's presentation, and these questions will be answered during the Q&A session. And please make sure to not submit any questions into the Q&A or the chat box, just to make sure that everything is in the Q&A. If we do run out of time during the Q&A session, we will follow up with each of the attendees that had questions that weren't answered directly offline following the webinar. And today's presentation will be available to download during the Q&A session in the Files pod. It will also be distributed in a separate email following today's session to all attendees. And again, if you're experiencing any technical difficulties during today's event, please notify us through the chat box and we will do our best to troubleshoot. And on that note, I will hand it over to Brian Riccacci, SARM's Manager of Policy and Research, who will be moderating today's webinar.
Yeah, thanks, Adam. Like Adam said, welcome everybody to the webinar on the changes to prompt payment. Today we have with us Mr. John Lax. I'll just do a quick introduction, John, and then you can take it away. So my role in this as moderator will be to just ensure that we've got the Q&A questions being answered. Anyone in the crowd, if you feel like a question, you can put it in the chat box at any time, and I'll make sure we get to it in the Q&A, just so if you have something you don't want to forget till the end of the session, you can throw it in there, but we won't be answering until the end. So yeah, with that, I think Adam's covered everything else. So I'll just start off with John is the Director of Industry and Stakeholder Relations with Priority Saskatchewan at the Ministry of SaskBuilds and Procurement. John has a 20-year career in the private and public sectors, including roles in agricultural pharmaceuticals, insurance, and Crown Communications. Immediately before joining Priority Saskatchewan in 2019, John was the Director of Advocacy and Communications with the Saskatchewan Construction Association. In that role, John was instrumental in designing, organizing, and driving prompt payment legislation in Saskatchewan. So with that quick intro, John, I will shut my mic off and you can take it away, sir.
Thank you very much, Brian. Thank you, everyone, for taking the time to be here today. I will start by noting that I'm a little bit under the weather, so you may at some point notice that I either cough or I'm huffing on a Vicks inhaler or something. I apologize for that, but we will struggle through this together, I'm sure. Thank you very much for the introductions, Adam and Brian. Again, John Lax, as Brian said, born and raised here in Regina. I have a wife and 3 children that I live with, and they are my absolute world, but I swear my children wander around licking doorknobs, so there's always someone sick in my house. Currently that person is me. This is the first time I have used the Adobe Connect system. I will admit it is incredibly slick, but it's a little outside the norm for what I usually do. Usually I tell people that I'd rather have a conversation than give a lecture. But today, just to make the system work smoothly, please, if you have questions, enter them in the Q&A. The advantage of doing so is that we have a record of all the questions and we can make sure we answer them. I will work with Brian and Adam to do that after the session if we don't get to everything. That said, I will also add that I much rather would have a conversation. So please, all of you view this as the start of a conversation, which means that if you don't get to ask a question today, or you think up a question tomorrow or next week or next month, I am not hard to find and track down. Feel free to give me a call. I'm happy to chat with you about these things as we go forward. All right, so let's begin. Prompt payment, Saskatchewan's new construction contract legislation. Today I'm going to run through what prompt payment is and why we got here and why we did this in the first place, the specific Saskatchewan regime, how we think it will work, and what you can expect as an owner. I will preface all of this by telling everyone here that I've done this presentation many times. This is, in fact, the third time in the past 2 weeks. Um, I give the same presentation to owners and to contractors. I do that for a very specific reason. I want everyone to go in with the same understanding. I have also done hybrids of this presentation with lawyers, and I've been in many presentations with law firms presenting on this as well. And so I will admit up front, you are going to get a lot of answers that are sort of non-answers. Because the fact of the matter is this is not just an update to legislation. This is an entirely new regime within the way we do construction in the province of Saskatchewan. And consequently, there are a lot of things that will need to be sorted out in the courts, and that won't happen until we have some adjudications and some challenges and some other things happen. But we can expect, given the experience in the UK and the experience in Ontario, that we probably will have a pretty effective regime, and nobody should be panicking about it. It will require that you change the way you do business, but there are probably some pretty big advantages here. So, why are we doing this? Well, a pay whenever culture developed in construction. This is no one's fault. It is just the nature of the industry and the nature of the type of work. If you go down to the grocery store and buy an apple, you pick up an apple and you know what the apple looks like, and you pay them, 50 cents for it, and you leave with your apple. When you are buying construction, comparable to information technology, you are buying a concept by and large, and then somebody has to come and put together that concept so that you have a tangible asset, whether it is a building or a roadway, or in the case of IT, a software system. And the fact is that it may not look or work exactly the way that you had envisioned in your head. And that's just the nature of buying these sorts of things. However, because that's the nature of buying these sorts of things, what happened was it became normalized for people not to pay their construction bills while they considered if enough work had been done in order to justify the bill, or if they had 8 different things on an invoice, but they didn't like one of those things, all 8 things would be held up. So over the course of decades, this just created a culture where construction companies carried a lot of receivables and in many ways felt like they were financing projects for owners. And in some cases, to be frank, they were financing projects for owners. So one of the other things I will touch on here is it is important to understand how construction works. Most of us think of the big construction companies, the PCLs, the Grahams, the Birds, the Leadcors of the world, and we think these are big companies that build things. And yeah, they're big, powerful companies, but they don't actually build things per se. It is the trade contractors they hire who actually build things. Um, oh, we still have a problem with sound?
I can hear you.
Adam, I'll let you look into that. I'll keep presenting here. Okay, so what we have are general contractors and trade contractors in the construction world. And you hire a general contractor who then hires all of the other people who do the work. General contractors tend to only do or self-perform 10 to 15% of the work in any other particular or any project. What you have are specific companies whose skill set is either earth moving or pouring concrete foundations or creating concrete structures or putting siding on buildings. And then there are different expertises in siding. There you have windows, on and on and on. So you have 30 or 40 different sub trades, and depending how complicated your project is, you may have up to a dozen or 2 dozen different sub trades involved in your project. When we think about these sub trades, they are not the big, powerful companies that can finance things. In fact, 92% of companies in the construction industry in Canada have 20 employees or fewer. 74% of companies in construction in Canada have 5 employees or fewer. This really is an industry that is made up of mom and pop shops, or a pair of brothers, or a father and two sons. Quite often there is a wife at home who is doing the receivables and all of the administration. That is pretty normal for the industry. And consequently, when big companies don't get paid, or there are questions and the money does not flow down through the supply chain, and in construction, they typically refer to a supply pyramid because it's a little more complicated than a normal supply chain. But when money doesn't flow through that supply pyramid, there really are no remedies for contractors who go unpaid on in progress work. Now, of course, at any point, someone can get a lawyer and sue. But when you're a small company and you're part of even a big project, let's say a $2 million build, but your part of it is only $50,000. And when you look at the average profit margin for construction in Canada is 6.2%, on that $50,000, by the time you hire a lawyer and go through even half of the court proceedings, you have eaten up all of your profit. And you start actually eating into your capital and your operating costs. So the court system, while effective at being perfect and consistent, is not really a solution to the problem that contractors were facing. Yes, there we go. So what is prompt payment? Well, prompt payment is a regime or an idea that was thought up a long time ago. Canada is about 30 years behind the curve here. All of the former Commonwealth countries, so Australia, New Zealand, the United States, the UK, they all have prompt payment legislation. In fact, in the United States, there's prompt payment legislation at the federal level and in 49 out of the 50 states. The only state where they do not have prompt payment legislation in the US is New Hampshire, the same state where they put live free or die on their license plates as the state motto, which gives you a sense of the kind of rugged individualism they're all about. But you also find prompt payment across the UK, throughout much of Southeast Asia, including the Philippines. So what I can tell you is prompt payment regimes exist in a lot of places, and they are not the end of the world. They do not mean that construction halts. They do not make it impossible for owners to do business. They do not make it even more difficult to build things in most cases. The other thing, and I always have to make this point to contractors, prompt payment is not a silver bullet. It does not make all of the problems I have talked about go away. In fact, I talked about how many of these problems developed over generations. The prompt payment amendment that has been created in Saskatchewan to introduce a prompt payment regime is actually an amendment to the existing Builders Lien Act. Now, the Builders Lien Act has a whole bunch of rights that contractors can use within it that nobody uses. And that's a cultural thing. And in fact, one could make a pretty strong argument that if a contractor did try and use some of those rights, they may find that they no longer exist because they have not been used for so long. Prompt payment may end up being the same thing. There are rights and tools in prompt payment that if the industry does not use or does not use properly, they may become ineffective or unusable. All right, so the whole point of introducing prompt payment is to change culture. It is going to cause disruption. It is going to mean you are going to need to do business differently. Prompt payment is made up of two parts. So there are payment requirements, payment rules, and then there is a mandatory dispute resolution process that anyone can get dragged into and any party can actually initiate. There are some rules around it, and it is not meant to be perfect. It is also not meant to deal with the entirety of your construction project. Prompt payment really is about the monthly or the progress invoicing cycle. So you're not likely to see adjudications on an entire $10 million project. Instead, the adjudication will be tied to what I'll get to in a few minutes here, the proper invoices, which are the monthly or the progress invoices, and disputes around those. It really is designed to keep the building process and the financing of the building process moving as we work through more fundamental disagreements that we may find in this process. Now, the legislation came into force on March 1st, 2022. It was passed in 2019. The pandemic delayed its implementation. It does not apply to any contract that was signed before March 1st. So one of the questions that had come in beforehand was whether there have been any adjudications or any filings for adjudications yet, what the value of those were. There has been nothing so far. And I'll explain the timelines here in a little bit, but the fact is that you're not likely to see prompt payment actually impact a project until at least 65, 70 days after shovels first hit the ground, because that's how long it would take for an invoice to come and then not get paid and somebody to get upset enough to use one of these mechanisms. Let's take a look here. So the courts are likely to interpret this as meant to change behavior. That is what they did in the UK. Where in the first 10 years that this existed, there was 100 years of case law created. Canadian courts have not historically been shy about relying on UK case law. And in Ontario, the initial impression seems to be that where cases do come up, the courts are adhering to a sense that, no, this legislation was meant to change behavior, so people need to live up to the standards that are in it, which also means they need to understand the standards that are in it. So, what are the elements of the legislation? And I know much of what I've said sounds scary here. Please don't feel like it's that scary. I will pass along to Adam as well a copy of the amendment that prompt payment was passed as for the Builders Lien Act. So it is all of the prompt payment stuff pulled out of the Builders Lien Act. It has now been integrated in, so it does, the legislation doesn't actually look the same as what I'll share because it's been mixed into the existing Builders Lien Act at this point. But I do have a copy of all of the things that actually build prompt payment. When you look at that, look at it just like you would a choose your own adventure book if you read those when you were a kid. It is a series of if-then statements. So if this happens, you have two choices. And if you make this choice, this is the next thing that happens. If you make the other choice, somebody else further down the line has to make a choice. So don't read the document straight through, but rather read it with, I'm going to make this choice, so I jump to whatever clause it happens to be, and it'll make a little more sense. But where does prompt payment actually start? Well, prompt payment actually starts with a proper invoice. A proper invoice is not the same as an invoice that you would see today. The reason it's not the same as what you would see today is because there's never been any need for anyone to have a proper invoice. The proper invoice is defined in legislation. It requires that you list who the contractor is, who they're working for, what period the work that's being invoiced for is covered in, what the work is, what the value of the work is, and importantly, there's a final clause that says, and anything else prescribed in the contract. Okay, what does that mean? Well, what that means is that if you want to have, and there are good reasons why you might want to do this, if you want to have your contractors title their proper invoice as a proper invoice, you can do that in the contract if they agree to it. You can also say that we will not consider anything a proper invoice unless it is, delivered with a red balloon. Anything you come up with, you can include in what that proper invoice must be. Now, I would be careful if you get too unreasonable, like a red balloon. The courts may view that as unnecessary, but you can contract in that, the proper invoice has to include X number of things with it. So, proper invoices will be required monthly unless otherwise stipulated in the contract. Well, what does that mean? Well, what it means is, again, whatever you can get your contractor to agree to. So if you find that for administrative purposes, it is easier if you get billed every 2 months so that you only go through this process half as often. If you want to get billed quarterly, and you can find a contractor who will do that, and you probably will be able to, but let me remind you that they are going to bill you for carrying your costs for that extra amount of time. In some cases, particularly residential construction, where they're actually financed on bank draws at certain points. So once they have a foundation poured, once they have a frame, and then once they're at lockup, these are different progress draws that they get their money from the bank for financing. So in the residential sector, it very well may be the case that they build their contracts based on we will provide a proper invoice to the owner as we hit these bank draws, because that's when the owner can actually pay them. Again, you can contract anything you want here. What you cannot contract is once a proper invoice shows up, you have 28 days to pay it. There's no way to get around that. It's a 28-day cycle now. So if you have people who are going to be on vacation, but they need to sign off on this stuff, you have to find ways to deal with that. If currently you run everything past a certain committee or a council, you're going to have to find ways to address that. Most of the creative ways to address that are going to be in being very careful and understanding how you receive your proper invoices. Proper invoices also, and this is a sea change in the industry, proper invoices cannot be contingent on prior certification by the owner or their consultant. That's an architect or an engineer. Historically, that has really been the way that a lot of owners manage these things, is they said, you can't give me an invoice, or I'm not going to accept your invoice until my engineer has said all of this is good and they're comfortable with it. Doesn't work that way anymore. So you have to address those sorts of things in the contract, but you can't write into the contract that you can't invoice me until a certain person or representative approves it. Instead, you're going to have built into the contract, our invoices show up on the 5th of the month or the first business day thereafter every month, or we get invoiced quarterly, or we get invoiced biannually, whatever it happens to be. But once you get that invoice, you're going to have to pay it within 28 days. There we go. Okay, so the payments, oh, I jumped an extra page. There we go. So payment cycle. You have 28 days to pay, but you should think of it actually as two discrete 14-day periods. You have 14 days to look at the invoice and decide, is everything that is on that invoice done and done in a satisfactory way that I'm comfortable with? And if the answer is no, before those first 14 days are up, you want to issue a notice of dispute. So a notice of non-payment. And in that notice of non-payment, you will have to identify what you are not paying and why you are not paying it. It is important to get these rationales right, because if somebody comes after you with that dispute mechanism, it is very likely that the adjudicator is going to look back at your initial, why did you say you weren't going to pay it? Now, you could miss that 14-day date without filing your notice of dispute and still not pay it 28 days, but you may have an adjudicator look very unfavorably on the fact that you couldn't, within 14 days, say that you weren't going to pay it and why you weren't going to pay it. Now, here's the other thing that really changes, and it's why contractors pursued this. And a note, I know that Brian had mentioned it off the hop. Many of you may not have fully picked up on it, but I was the director of advocacy and communication for the Saskatchewan Construction Association when they were fighting to have this law enacted. I then got asked to move to a different position where I am now with the government of Saskatchewan, and I thought that I had escaped prompt payment. But they looked at me and they said, oh, well, you understand this as well as anyone, so we're going to tag you with being responsible for explaining it to government stakeholders and owners and various other things. So karma has led me here to where I do this presentation all the time. Like I said, happy to answer questions after the fact. But having been at the table as this was developed and put in place, there are a few things that I can provide context and clarity to owners on. One is that, let's go back to that example I had earlier where I have an invoice come in, a proper invoice, and there are 8 things on that proper invoice. And let's just say, for argument's sake, they're evenly distributed 12.5% to each of the things. If I don't like the lighting, if I think the lighting is not what I asked for, it's not to the spec, and I say I'm not going to pay for that lighting. Historically, what has happened with the majority of these kind of disputes, and I'm not saying everyone here does it, I'm saying a lot of owners do it. the entire invoice, the entire 100% of it would go unpaid while we fought over that 12.5%. That is no longer the case. In a prompt payment world, you are disputing that 12.5% for a very specific reason. Everything else remains payable. The remaining 87.5% of that invoice that I'm fighting over is payable at 28 days. And if I try and play games with that, as we'll get to in the explanation here, an adjudicator is likely to look unfavorably at it. And so far, the examples do look like the courts are not going to look favorably at it either. So you want to take the 14 days, issue your notice of dispute if you don't like the lighting. If you don't like the siding either, dispute that too. One of the things here I will jump in and add for context as well. Nothing in prompt payment is meant to make you, as an owner, pay for unsatisfactory or incomplete work. If you look at it and you say, this is clearly not what I wanted, this is clearly not up to spec, this is clearly not good quality work, or you look at it and you say, you're invoicing me for, having installed the cabinets are still sitting on the floor, they're clearly not installed, don't pay for it. My advice to you right now is file a notice of dispute and have that conversation. The whole point here, the whole cultural change that this is meant to drive, is to have an actual conversation. Do not let someone use this to bully you into paying for things that you shouldn't be paying for. It's not what it's meant for. And anyone on the other side of the table playing that sort of game is likely to find an adjudicator who is going to smack them for it. So balance of the proper invoice remains due within 28 days. Let's take a look here. Notice of dispute does not prevent the dispute resolution process. It does other things, and not filing a notice of dispute does not actually mean that you have to pay it 28 days. You can still not pay. You just have, one, not given your contractor warning, and two, or at least not proper warning, and two, left yourself probably a little bit exposed in any sort of adjudication process that comes forward. But if you do file a notice of dispute, you will defer any interest on overdue payments that you have, because payments aren't actually overdue until the 29th day after the proper invoice, or until an adjudicator rules that it should be paid, at which point your interest clock would start. That's not the end of the world either way. But ultimately what we're looking for here is discussion. Okay, prime contractor, there we go. Okay, so I'm using the term prime contractor here to imply a general contractor. But sometimes your general contractor is not a general contractor. So that is to say, we're not actually hiring PCL or Graham or Ledcor or Bird or one of these big generals. Instead, we're doing, let's say, a mechanical project. So we have hired a mechanical company. That is who our contract is with. That means in that case, they are the general contractor or the prime contractor. At any rate, a prime contractor needs to take that notice of dispute that you file with them and let their subcontractors know within 7 days. So they can't delay this stuff. And this is part of how prompt payment works to prevent some of the games that have historically been played. Because you have an owner and you have the prime contractor, and behind the prime contractor, you have a whole bunch of subcontractors. Prompt payment rights do not belong just to the prime contractor or just to the owner. Prompt payment rights belong to all of these other people in line behind the prime contractor, which means if a prime contractor is not getting paid, they have a decision to make. So let's say that Adam and I have a contract. He's the owner and I'm the prime contractor. And Adam has decided that the piping that I have put in is not up to spec, and so he's not going to pay for it. Well, I didn't actually put in the piping. I subcontracted that out to Brian. So my payment is due 28 days after I provided the proper invoice. My payment to the subcontractor, Brian in this case, is due 7 days after my payment is due. So I'm due payment at day 28. Brian is due payment at day 35. At day 36, when Brian hasn't been paid, he can initiate an adjudication against me if he decides he wants to do that. If he disagrees that that piping is not up to spec or not quality, he can adjudicate against me, which means from the moment I get the notice of dispute, or if I don't get a notice of dispute, from the moment I don't get paid, I have a decision to make. I either have to adjudicate against my owner, or I have to stand firm with my owner and say, no, I don't think this is good quality. And I may well end up in an adjudication for making that decision. These are business decisions that people are going to have to make, but it's not anymore a world where just because an owner and a prime agree that something isn't up to spec, that that's the end of the issue. Those rights keep falling down the line. So when Brian is making his decision about whether or not he is going to initiate an adjudication, that's the dispute mechanism, and I'll get to a deeper explanation of that very shortly here. But when he is making that decision, he has to make it knowing that his payments are due to his subcontractors and suppliers 7 days after. So in this case, at day 42. And it just cascades down. So at day 49, payment is due to somebody else. At day 56, payment is due to another party. And it goes on and on and on until everyone is paid. And as I mentioned before, construction has a supply pyramid that can get pretty lengthy and pretty complex. So at any rate, yes, disputed, paid accordingly. Oh, okay. So I'm going to go back in that, let's say that 12% example that I gave earlier for the lighting. If myself and the lighting contractor agree that, hey, you know what, actually we did make a mistake, the lighting isn't what we were looking for, what we can do is start talking with the owner and seeing what we're going to do, but we can just knock that off of the proper invoice. And we can go ahead and decide how we're going to fix that, and we'll include the cost for the lighting on the following proper invoice. There is tons of opportunity to talk and come to consensus decisions within this process. That is the way it is designed. That is the way it is meant to work. That is the cultural change that it is trying to drive, is talk to your contractors, be reasonable, and expect them to be reasonable. So let's say that in that lighting example, this is option B that we're running here. Let's say that the lighting company says, no, we don't think it's actually that bad, but we get what you're saying. We'll change the fixtures. But, we need, of the 12.5% of the invoice that was, we need at least 35% now to cover the wiring and the back end stuff that there's actually nothing wrong with and we know works. We can come to that agreement. We can say, fine, we'll cover X% cost of that or whatever it happens to be. Nothing wrong with doing that. And then we can all agree to bump the rest of it to the next proper invoice or to whenever it's actually done. But assuming that we can't come to an agreement, we get into a dispute. The legislation lays out a clear dispute mechanism that is the adjudications. The adjudications are meant to be quick and dirty. They are rough justice. They really are meant to happen much quicker and much more cheaply than court action. But because they happen more quickly and at a lower cost, they are not aiming for the perfection that the court systems are aiming for. The adjudication process is overseen by an authority. That authority is the Saskatchewan Construction Dispute Resolution Office, or SCDRO. Because everyone knows we don't need more acronyms, but the SCDRO is an arm's length subsidiary of the Saskatchewan Construction Services Corporation, which is a nonprofit which manages certain services for the industry. Now, some of you may have some alarm bells going off here. Why is a construction nonprofit managing a system that oversees this? What I can tell you is that in Ontario, they went with a for-profit model for prompt payment. In Saskatchewan, we have gone with a non-profit model. So somebody had to set something up, and it was the industry who pushed for it. So it was the industry that was left to set up and bear the costs of having an organization to look after it. The SCDRO has what's called a governing committee. Now, the governing committee really operates like a nonprofit board of directors. And it has a very strictly outlined set of members on that governing committee. The only reason that it is not a board of directors is because the SCDRO itself is, as I said, a subsidiary of another nonprofit. But that governing committee has representatives from the Provincial Architects Association, the Provincial Engineering Association, from the Dispute Resolution Office. It has public sector owner representatives. It has private sector owner representatives. It has trade contractor representatives. It has general contractor representatives, on and on and on. And what they are tasked with doing is making sure that this entire regime works. Where you do not need to worry is that they do not actually play a role whatsoever in any adjudication. They are responsible for setting up a complaints process, but they are not responsible for resolving any particular issue within any adjudication. If there's a problem with an adjudication, the courts actually address that. What the SCDRO is responsible for, and I have it in a later slide here too, so I won't belabor it too much here, but really they have to train adjudicators. They have to have a public website showing who the adjudicators are and making sure that for anyone, perhaps you folks, if you need an adjudicator, you know where to find them. You can take a look at what their skills and their backgrounds are. This group is responsible for making sure that adjudicators have the appropriate training, on and on and on. So it's really just administrative stuff. They don't play any role in the actual judgment or dispute mechanism itself. The adjudications matter, though. Adjudicators have broad discretion. And the adjudication is binding on a strict timetable. So what that actually means, and I will belabor this as I go through the rest of this presentation. The adjudicators make rulings that have the force of a court order until a court overturns it. And what this can do is change the power structure and dynamics in construction. Because historically, you would have contractors who were suing somebody for not paying them. We may get into a world here fairly soon where you have owners who have always held the money and only paid when they wanted to, who are suing contractors to get their money back because an adjudicator said, no, they did what you asked them to do. You actually do have to pay them, or you have to pay them some portion of that money. The cost of adjudications is borne equally between both parties to the adjudication, unless, and this is important, adjudicators actually have the authority to look at any adjudication, and if they feel it was malicious or vexatious, they can say, no, you know what? John, Adam, you two got into a dispute. John, as the contractor, was clearly wrong. This never should have gone to an adjudication. John, I'm assigning 80% of the cost of this adjudication to you, or 100%. They can assign any number they want. If they wanted to assign, I don't know, 16.827354 percent of the cost to one party and the remainder to another, they can do that. They have full discretion to do so. I will also note, all of this may sound terrifying, but Ontario's prompt payment regime came into place in 2019, the same year that our legislation passed, but ours didn't come into effect until this year. Ontario has 13 times the population of Saskatchewan, and their construction sector is even bigger than that, proportionally speaking. In the first year of prompt payment in Ontario, they had 30 adjudications. In the second year, 2020, they had 50. I don't actually know how many they had in 2021, but what I can tell you is this is not the sort of thing where, oh my God, every project is going to get adjudicated, and every invoice is going to get adjudicated. Not the way it works. And in fact, that's how many adjudications they had. We don't know how many they had filed, but you're going to find you may end up in a world where a lot of times people file for an adjudication, but no adjudication actually happens, again, because of that cultural change where we're actually talking now. And there are very good reasons why both parties may not want to actually go to an adjudication, even if someone wants to stomp their feet and threaten to do so. I've already covered this off, so we don't need to talk about that. Dispute timelines. Okay, so what happens? Well, Adam and I are fighting, and we're fighting about the lighting. And so what happens is we can't come to an agreement, and I either need to adjudicate against Adam or my lighting people are going to adjudicate against me. I don't want them adjudicating against me because I think, they actually installed the lighting. The spec wasn't as clear as you as an owner are saying it was. So what I am going to do is file the adjudication, and we'll bring in a neutral third party to decide what we should do about this, I don't know, $15,000 on an invoice or whatever it happens to be. Okay, so I file for an adjudication. That then means that Adam and I have 5 days to agree on an adjudicator. If we cannot agree on an adjudicator, the authority will appoint one for us. They have 4 days to do so. Now, the act is written in a way that it sort of assumes that the moment an adjudicator is decided, they will be on site and present and ready to start taking things in. I don't think this is actually going to be the case. Give me one moment here, folks. Sorry. Think this is going to be the case. We're going to have retired judges, retired lawyers, retired accountants, retired construction people. Heck, there's a whole bunch of you that are probably eligible to become adjudicators. Basically, all you need is 10 years of dealing with construction issues. So the fact of the matter is once you decide on an adjudicator, whether we decide in that 5 days or it takes the whole maximum 9-day cycle to find one, you then have to get the adjudicator to agree, and they've got to open up their calendar a little bit. So I'm expecting that you're probably going to see anywhere up to a 3 to 10-day gap before the adjudicator is actually on site. So at any point, once the adjudicator is agreed and we've got a time that the adjudicator is going to be there, and remember, all of this is happening after an invoice has gone unpaid for 28 days. And that invoice only came after the contractor worked for a full month, 30 days usually at least. So we're talking 58 days after shovels hit the ground, and then another 9 days, and then another maybe 3, 4, 5, 10 days, whatever it is, to get the adjudicator in place. So these things are not happening at lightning pace. They're happening faster than we're used to, but it's not like it's rushing at us like an avalanche. Anyway, within 5 days of appointment, the adjudicator must be provided with all documentation from all parties. Now, I will clarify, as I said earlier, I presented with some lawyers on this, and we have some disagreement. There is a lack of clarity in the legislation. So one of the most talented lawyers in the province, and I respect the heck out of her, her and I disagree on what this actually means. Her reading is that whoever filed for the adjudication, in this case me, I'm adjudicating against Adam. Sorry, Adam. Seemed like a great guy, but I want my money. She reads it that I have 5 days to provide everything to the adjudicator, and then Adam has an additional 5 days after I filed my paperwork to file his paperwork. That is not how I read it, and we'll have to sort out how it goes because there's no source here that can tell us what it actually means. We're going to have to find out from the authority, and I just have not had this conversation with them yet. But this is either a 5 or a 10-day process, but it is crucially important because historically, if you were going to go to court fighting over the lighting bill, you would have forever. Lawyers ask for continuances and discontinuations and additional time and deferred hearings, and they take forever to put everything and read it and put it into a very clear logic chain of what argument they're going to make. We don't have that luxury anymore. I, as a contractor, have 5 days to give to the adjudicator what is my argument. Why should I be paid? And in doing so, I'm trying to tell a story. I'm trying to convince that adjudicator that I've done what I was asked to do and that I deserve my money. Whereas Adam is doing the exact same thing. Whether he is doing it in parallel with me or after me, he is trying to tell a story of, look, we asked for X, Y, and Z, and what we got was A, B, and Z. And while there is some similarity, it's not the same, and we're not comfortable, and we just haven't had time to work these out. An adjudicator very well may take either one of these to be the better or more compelling story. So that is one of the things that is crucial. Also, I should let everyone know, when you sign your contracts, you cannot specify that a particular adjudicator has to be used. The adjudicator has to be selected or must be selected at the time of the adjudication. So even if you write into a contract, if Adam and I sign this contract and Adam has written in that we are going to use, I don't know, Sam as our adjudicator, the fact of the matter is come time, if I don't want to use Sam, Adam has no way to enforce that mechanism. The legislation specifically prohibits the writing in or determining an adjudicator ahead of time. And this is for very good reason, quite frankly. There are good reasons why Adam and I might agree on somebody to be our adjudicator. It could be the case that, there's an accountant who dealt with construction for years, who lives just up the road, and we both trust and are comfortable with the guy, and it's a $15,000 invoice, and we're going to let him make the decision, and we're going to live with it. And we think that's quick, easy, efficient, and we now have a mechanism to make it binding, so that's what we're going to do. There are other times where maybe we wanted to use Sam up the road because he has that skill set, but our dispute is actually something very specific. Maybe it is about something very specific about masonry or masonry installation, in which case there is another adjudicator who is an expert in masonry. And we figure that it's probably better to bring that person in. So anyway, that's the rationale. Okay. What am I doing here? Why isn't this hopping? There we go. So dispute timelines. Once the adjudicator has all of their documentation, that is the story that we're telling them, whether that is a 5 or a 10-day process. The adjudicator has 30 days to issue a ruling. So this is much quicker than the old court system that most of you would have been used to. The period can be extended for 14 days so long as everyone agrees. If any party to the adjudication disagrees, then you can't extend it. Most adjudications are limited to covering one thing. So in the example I've been using, Adam and I are fighting over the lighting, 12.5% of the total invoice. But let's say that Adam also has a problem with the siding, which is another 12.5%. It may be the case that as a general contractor, and having discussed with my 2 involved trade contractors, that we decide we don't want to go to multiple adjudications. We want to go to one adjudication because this is all one invoice. We're dealing with the same owner. It's the same project. We all understand there's no point expanding our costs or making the process more complicated than it needs to be. So what we're going to do is simply combine it into one adjudication. So you can do that, but you have to actually go out of your way to do it. Most of them are designed to cover one particular thing. Again, I have talked about the adjudicators having broad discretion. Their rulings have the strength of a court order. So Adam and I go to an adjudication. Sam makes a ruling, and Sam rules that Adam has to pay me 2.5% of the 12.5% of the total invoice that I was looking for. The other 10% can be held off for valid reasons that Adam outlined. Okay. If Adam says, I'm not giving you that 2.5%, I'm still not doing it, I can then go to the Court of Queen's Bench 10 days after I have that ruling in hand and have still not been paid. I can go to Court of Queen's Bench, and the ruling from the adjudicator has the force of a court order. So the court can direct the sheriff's office to go into Adam's bank account and give me that 2.5%. The other thing, and this again, another giant sea change in the industry, is I can discontinue work on the project until I am paid the money that the adjudicator has awarded. And Adam is on the hook for reasonable demobilization and remobilization costs. And if I pull out of this contract, which, just to be clear here, I don't think anyone is ever going to pull out of a contract for 2.5% of, a monthly invoice. It's just not reasonable, but it is within the framework of this legislation. So Adam cannot simply replace me because I have a valid contract with Adam. It is, in the court's view, Adam who has not lived up to the contract. So if we want to break that contract, you have to go through the process of breaking a contract with the other party and being responsible for being the one breaking that contract. So if you lose an adjudication, just pay. Let's take a look here. Just like if you're going to be late paying, if you can't make payment by 28 days, if you're going to need 34 days, or hell, even if you're going to need 37 days, talk to your contractors. Tell them you're going to need that much time. Tell them exactly why, and see if they'll make the business decision to hold off on filing an adjudication. Plus, they can file for an adjudication too, and you can all drag your feet because you have that 5 days to agree on an adjudicator. So you could just not agree on an adjudicator, which is leaving it up to risk who's going to get appointed by the SCDRO. But there are gaps here. There are room to take a little bit more time to solve these things. So you talk to your contractors, tell them why, and then if they aren't paid by day 34, day 37, you can expect them to go to that adjudication process. Let's take a look here. Oh, so you can make an application for judicial review of an adjudication. Let's say that I really don't like Sam's ruling. I'm really upset about it. As far as the legislation is concerned, doesn't really matter that I don't like it. Unless I can demonstrate that Sam is completely incompetent, there was outright fraud, or that Sam, it turns out, is actually Adam's brother or brother-in-law or something like that. Unless I have grounds like that, the courts will and can, and the legislation actually directs them to dismiss without cause. They won't even look at an application for judicial review. That doesn't mean I can't sue. It doesn't mean I can't go through the court process. It just means that I can't ask for judicial review of the adjudication ruling itself. The adjudication ruling will stand until a court goes through the full process of reviewing everything and decides otherwise. So, I already talked about this too. Any party owing on an adjudication outcome has 10 days to pay in full. Again, if you need a few more days or whatever, you're not going to have a great relationship at this point if you've gotten here. But if you are here, you may want to talk to your contractor and say, we need 12 days. And if that'll keep them from walking off the job at day 11 and give you till day 13 to make that payment, it's probably in your best interest of doing that. And I've already covered this as well. So suspension of work, not paid within 10 days, entitled to reasonable costs with demobilization and remobilization, can't replace the contractor. Interest on overdue payments. I mentioned this earlier with the notice of dispute. So if you don't file a notice of dispute and don't pay, your payments are overdue starting on day 29. If you file a notice of dispute for that lighting, your lighting payment is not actually overdue until an adjudicator has ruled against you. Now, that said, the interest rate is the greater of what's in the contract, always know what's in your contract, or the prejudgment rate in Saskatchewan. The prejudgment rate in Saskatchewan is laughably low and largely irrelevant. Basically, unless you're in a multi-million dollar monthly payment for some strange reason, your interest is going to be very, very low, negligible from almost everyone I've talked to about it. So how will all of this work? I am aware of the time. We will be wrapping up fairly quickly here. There are very few exemptions to prompt payment. They really include mining, facilities, and operations. We don't know yet if that includes things like the offices for Mosaic or Nutrien. The suspicion is no, that this is actually talking about the facilities where they extract minerals from the earth. And the reason for that was the industry agreed that mining facilities actually do end up with quite often monthly or progress payments that are 20 or 50 million dollars, and nobody felt like it was reasonable to have a neutral third party come in and make a 30-day decision when that kind of money was on the line. The work for engineers, architects, and surveyors is exempt. Now, if you as an owner hire an architect and your architect is handling all of your procurement, prompt payment still applies to you as the owner. It applies to the contractors and everyone in that construction chain, but your engineer doesn't have the ability, and they'll never give you a proper invoice. They don't have the ability to adjudicate against you or the contractors. I don't know why that exemption is there. And there is some suspicion, at least from those groups, that that exemption will not be there very long. But for now, it is. And so operate as if it is, and it will continue to be. Sask Power work relating to power transmission. So this is their high voltage stuff. Again, it does not apply to their satellite offices or their head office. You know, if they're replacing a window above someone's door at a facility in Regina or Saskatoon, prompt payment will apply. But if you have people going out and actually working on high voltage transmission, doesn't apply. Also, prompt payment, as I mentioned before, is an amendment to the existing Builders Lien Act. The Builders Lien Act does not apply to the Ministry of Highways. Again, we don't know if this includes or doesn't include office buildings. My guess would be no. But where it doesn't apply to the Ministry of Highways is because you can't lien a public highway. So the Builders Lien Act has just never applied to it. Prompt payment is built into the Builders Lien Act. So by virtue of that, and almost by accident, it doesn't apply to some of those things. It also will not apply to federal projects, and it will not apply on reserve land. Reason being that both of those fall under federal jurisdiction. However, and I don't know all the details here, this would be a different lengthy presentation. The federal government is implementing a prompt payment process or legislation of its own, and that apparently will apply in at least some of those contexts. Don't know what that looks like yet, though. Yes, okay. Authority of the SCDRO, already went through all of this. Again, that governing committee represents some very diverse interests. Here's some of the actual responsibilities of the SCDRO. Again, I ran through this, but at times they will appoint adjudicators if parties can't agree. They have to establish a complaints process and manage it, but that doesn't mean they get to overturn adjudications or play a role in adjudications. They have to develop procedures and reasonable steps to ensure adjudication is available. I can tell you that was one of the places that caused them the most heartburn early in this process, was how do we make sure that if someone wants to have an adjudication in Pelican Narrows, that we have capable parties available to do that dispute resolution. This one is a big slide. This is the adjudication fee schedule. So I will draw your attention to the right-hand second box from the top. Those are non-refundable fees for filing for an adjudication. So like I said, talk to your contractors. If you are not going to be able to pay until day 34, if you tell your contractor that, odds are they don't want to spend $1,000, or let's say in the case of the lighting where it was a much smaller amount, even they don't want to pay $500 to file for an adjudication when I've already told them I'm going to pay you, I'm just going to be 6 days late or even 10 days late. They don't want to dump $500 into doing that. Now, what you can expect is when you talk to them, if you tell them, I will pay you for certain on this date, if you don't pay on that date, you can expect a swift filing for an adjudication. That is how I expect the industry will behave, but they don't want to throw money away if they don't have to. Because remember, they file for an adjudication. You have up to 9 days to put an adjudicator in place. Then the adjudicator has to get ready. And then you've got that 5 or 10-day window to get the adjudicator all of the details. And then they have 30 days to make a decision. And then you have an additional 10 days before you actually have to pay. So if I, as a contractor, am looking at that and saying, I can do nothing and they're telling me they'll pay me in 6 or 10 days, or I could file for an adjudication and lose my $500, and then if they do pay me in 6 or 10 days, it all goes away anyway, but I'm still out my $500 or $1,000. I don't want to do that. Now, here's the next rub. You've got all of the costs that scale for an adjudication, so less than $10,000 is an $800 fee. And you can read it all. I won't read it to you. Once you get over $50,000, you're looking at an hourly fee. This can all get pretty expensive. One of the things that adjudicators are allowed to do is if they need a third party. So let's say we did hire Sam to do that adjudication, and Sam said, well, there's some masonry stuff here, and I don't understand it. I'm going to get a mason to come out and explain it to me. And that mason is going to charge me $1,500, including their travel time and expenses. And that $1,500 in charges that Sam is racking up hiring that expert, he's going to bill that back to Adam and I. And he has every right under this legislation to do that. Now, they have to be reasonable. If they're looking at a $4,000 dispute, don't rack up $2,000 in charges. This is meant to be quicker and cheaper than law. It's still not free. Anyway, these are what the costs look like. Let's say Adam and I are 14 days into our 30-day adjudication window. And we decide, you know what? Let's just split the difference. You pay for half the lighting or even 40% of the lighting, and we'll defer the other 60%. We'll deal with it later. If we agree to do that, we can phone up Sam and say, hey, Sam, that adjudication you were doing, stop. We don't need you to do it. Sam can say, okay, I'm not going to issue a ruling. Sam will still send us a bill for his time and effort so far. So we may still be on the hook for, in this particular case, $1,000. So we're each going to pay $500 to Sam, and Sam racked up an extra, I don't know, $200 in charges. So $600 each to Sam for running the adjudication. But Sam never actually gave a ruling, but Sam goes home. And what we get for that is that neither of us have to worry about an adjudication coming out and us losing outright. So there are lots of reasons and ways that this could be done, but understanding this is crucial. I would say the two most crucial things for you as owners to understand are what triggers prompt payment rights, and we go back, that's the proper invoice. Everything cascades from that proper invoice, all of it. So you want to understand what those timelines look like. And the next thing you want to understand is when rights are triggered, when are costs triggered, because costs will change people's behavior. So even if someone has the right to adjudicate, even frankly, if they should adjudicate, if you can find a reason or some common ground to prevent that from happening, you can probably buy yourself a bit of time, because nobody wants to dump the $5,000 or $1,000 non-refundable fee, let alone get into an adjudication they don't plan on letting finish. Like, God forbid anyone get into a dispute over $51,000 and decide 25 days into an adjudication that they've found common ground and they're going to get rid of it, and you're stuck paying the $250 hourly fee that was racked up over the course of that 25-day period. Next steps. Okay, so the new rules will force action and or communication. It is meant to drive culture change for all parts of the industry. This isn't just about owners. The fact is that contractors, and they know it, and I've been very explicit with them, you need to change your behaviors. You're giving a proper invoice now that they have to actually consider and pay or dispute. You'd better make sure that you're actually clear about what's on that invoice, and you'd better be clear that it's coming on time. So again, another place where the lawyer I mentioned earlier and I disagree is in the fact that the example I used, the proper invoice is coming on the 5th or the first business day thereafter every month. You could ask for pre-invoices. So Adam and I are working, and Adam could say to me, hey, I know your invoice is coming on the 5th, but do you mind showing it to me a few days earlier so my engineer and I have a few more days? You can lengthen that 28/14-day period to know if you're going to have look at your disputes or whatever else by having a pre-invoice. That is perfectly possible. I know lots of general contractors have already said, yeah, they're game for doing that because it makes life easier. If things shouldn't be on the proper invoice, we can not put them there. It doesn't trigger prompt payment rights. You can't control that, but you can certainly have the conversation. And that's really what we're trying to do here, is drive conversations. But we have to be careful. So again, I'm just talking about the disagreement here. So one of the things that one of the presentations I saw was a lawyer proposed, if I have a pre-invoice that comes on the 28th of the month, and then I have a proper invoice, which is going to come on the 5th of the next month, and the courts, we get into a fight about it, what is to prevent the court from saying, well, your pre-invoice looked exactly like your proper invoice? If it was no different, how come it didn't kick off prompt payment rights at this date, which changes everything in this cascading effect? So I'd recommend it to people. Make sure that when you have your proper invoices in your contract, say they must be labeled as proper invoices and no other invoices will be labeled as proper invoices. And that sounded reasonable to me. But there is an interpretation where if the invoice has to come on the 5th or the first business day thereafter of the month, if I as a contractor don't get Adam his invoice until the 6th, is it a valid, proper invoice? And it could depend on how you word things in your contract. So if you say it must be there by that date and it isn't there, then it probably isn't a proper invoice. If it's just an expectation that, our invoices are going to arrive or whatever, and I don't get it there till the 6th, maybe Adam says whatever, I don't care. But depending on how the contract works and the contract language and how you interpret the legislation, it may be the case that if I don't get my invoice to Adam by the 5th or the first business day thereafter, I have lost my ability to call that a proper invoice and for it to kick off all of the rights that cascade from a proper invoice as far as prompt payment goes. We don't know exactly what the answer to that is, but the fact is that one of the most talented lawyers I know thinks that it is the case that if a contractor misses that date, they don't really have the right or ability to enforce anything to do with prompt payment. So understanding as best we can and keeping abreast of what triggers rights, what triggers costs, crucially important. The other is you need to respond much quicker to adjudications. Historically, we have had a ton of time to meet with our lawyer, to gather everything, to file things the way we want. Now in an adjudication, you need to respond in a 5-day timetable. That is tight. So, ways to manage prompt payment as an owner. Understand the rules. Understand the builder's lien amendment. Again, I will send that to Adam if I haven't already. I don't think I have, my fault. But I will send it out to him so he can share it with you. It is now integrated with the Builder's Lien Act itself. But if you take a look at it separately, like I said, it's an if-then, choose-your-own-adventure book. But you read it 2 or 3 times, you'll start to get it. It'll start to make sense. Communicate internally and externally. Make sure you, your consultants, your project managers understand prompt payment. Make sure you're talking externally with your stakeholders about how you plan to manage it and what their expectations are. It's much easier if you're all on the same page. Challenge. My God, challenge when appropriate. If somebody bills you for something that is not done, or it's utter garbage, or it's just not up to the spec or code or whatever, don't let them use this to push you into paying. Don't. That's not what it's for. Go to the adjudication. And when you're telling that story, that clear, concise, this is why we're not paying X, Y, Z. I be crystal clear with the adjudicator and say, look, as we understand it, this is not meant to make us pay for things that are not done or not proper, and this doesn't meet the code spec. Here's exactly why. Tell a convincing story. Respond quickly and coherently to adjudications. So make sure you're not fragmented and disjointed. Actually tell a clear, concise story within those responses. Tactically, what can you do? Well, negotiate your contracts favorably. If it makes sense for you to get invoiced, heck, even on a town council meeting basis, like you want your invoices 7 days before those, find ways to work that in your contract. It's possible. You can contract anything you want for the invoicing period. You cannot contract out a 28-day payment cycles after the proper invoice. I would say arrange for pre-invoices wherever possible. If that means you have to tell your general contractor, don't worry, we don't plan on holding you to these. These are an administrative tool that we would like where possible. Some contractors may not be keen on it, some may, but you cannot make those enforceable. So if you get a pre-invoice and then you get the proper invoice and it's significantly different, there's nothing that you can do about that. The proper invoice is the proper invoice. And if you're going to challenge or adjudicate, you're challenging the proper invoice. That pre-invoice is not going to bear any weight moving forward. Because the fact is that when you're getting your invoice on the 5th, your general or your prime had to put that together 7 days earlier. And in order to do that, their subs had to have their stuff to them 9 days ago, 11 days ago, 13 days ago. It takes time to put all these things together. That's one of the biggest challenges in construction. Again, I've said multiple times here, but I cannot stress it enough. Recognize when rights are triggered, recognize when costs are incurred, and then understand that all of this is a risk versus reward exercise. That's really what we're doing here. Steps to prepare, review processes, review your contracts, your administrative processes, how your financing works to make sure that you're contracting in ways that make sense with the new payment cycle requirements. Now, it says here these steps should be taken in advance of March 1st, 2022. That was when I was talking to internal provincial government audiences. If you have not started doing this or you haven't done it yet, don't worry, you're not that far behind the 8 ball, but you should get on it fairly quickly. So final things, don't panic. I know this was a long presentation. I know there's lots of things I said that were hard and fast, and there were others where it was sort of non-answers or we don't know. The courts will have to bear it out. But where the rubber really meets the road here is talk to people. And heck, I wouldn't even be shy about being honest with your contractors that we really don't understand this legislation yet, but as we understand it, this is what we're required to do. Do you view it differently? And then have that conversation with them so that you're all on the same page and you expect these things. Understand your proper invoice dates, pre-invoicing where you can, keep talking. Even if you're going to be late, say we're going to be late. It's like I tell my kids all the time. There's no problem that you are ever going to solve by pretending it's not there for an extra day or two. With that, I will conclude my presentation and we can have a discussion or questions or a discussion about any questions you may have. I cannot have been that good that nobody has questions.
Thanks for that, John. I'll give you a second to maybe grab a drink and give your voice a rest. That was a lot of talking, but it was a lot of information and very thorough. So I guess right now we can move to the Q&A section. So if anybody does have a question, they can go ahead and enter it in the chat box, which is on my screen located in the middle bottom section, but it might be in other places. So we'll just give everyone a couple of seconds to just maybe come up with some thoughts and put that in there for now. And I'll try and keep track of it as we go through. I don't see anything now, John, but maybe I'll just start off with a question I had. Do you see in Ontario or the other prompt payment systems that have been set up, is this triggering more dispute resolution with contractors and owners, or is this just pulling away from the court system? Like, is it adding to the disputes, or is it just?
It hasn't added anything. What it's done is it's systematized a way to address issues that were already there. So I can tell you in the UK example, 20 years after they've implemented this, they used to have courts that dealt with just construction disputes. And those courts operated 3 days a week, 8 hours a day. 20 years later, those courts operate 1 day a week for 4 hours a day. But they have a significant number of disputes that go through adjudication. The other thing that happens here is that people figure out how adjudications work. And like anything else, people sort of learn how to game a system. They also learn there's no point adjudicating this because it isn't going to fly. Like there's enough cases where people have adjudicated this or that and it didn't work out. So people stop adjudicating those things. But ultimately, at the end of the day, the evidence is pretty clear that what it leads to is, I wouldn't say counterintuitively, but maybe a little bit surprisingly, better relationships. And I think most of that is driven by the fact that prompt payment gets really difficult to manage if you're not talking with people about prompt payment and about what their expectations are. And because those expectations are up front, we can sort of course correct a little bit differently. Like if somebody says, well, I expect this to happen at 9 a.m. on this day. And you say, well, our administrative processes actually mean that, we'll get it done, but it's going to be at 5 p.m. or you might not see it until 9 a.m. the next day. People, generally speaking, okay, fine, as long as it's 9 a.m. the next day. Because again, going back to that, nobody wants to dump the non-refundable filing fee for filing for an adjudication. Nobody needs to get into an adjudication. And the fact is that if you become a serial, I adjudicate everything, people are going to start to recognize that pretty quickly, and they're going to calculate it into the way they do business with you. So.
Yeah, for sure. Okay, I do see we have one in the chat box. Adam wrote it in. It must have came from the other one, but it reads, do the same rules apply when a request is made to receive payment of the holdback?
All right, so here we go. Prompt payment does not apply to holdback. You can still do a holdback, and an incredibly non-answer answer here. We don't 100% know. My suspicion, my strong suspicion, is no, and my reasoning for that is holdbacks are released based on a certificate of substantial completion. A certificate of substantial completion is not a proper invoice. And typically, no invoice comes in when one of those is given. Now, you may end up with a clever contractor who decides that the minute they get a notice of or a certificate of substantial completion, that they're going to file a proper invoice for that. I don't even know what that would look like given what you have to have on a proper invoice. But if they do that, there's now a proper invoice that is tied to it, and eventually someone's going to have to sort out that question. But for the time being, all proper invoice or all prompt payment rights are triggered by a proper invoice. And so if there is no proper invoice, there is nothing to anchor the prompt payment rights. So today, no, unless you get someone who's clever and gives you an invoice for the substantial completion, and I'm not too sure that's even possible. But I expect someone will try it eventually. But generally speaking, no. At the moment, there's really nothing that ties prompt payment and holdback together.
Okay, great. I hope that answers the question that we had. If there is anybody else that has a question, you can submit it to the chat now. We still have a couple of more minutes until 11:30, but we're not going to hold everybody hostage if everyone's satisfied with what they've had. I also realized that it was a lot to take in, so if there is a question that maybe comes up later in conversation or something after the presentation that you think of, feel free to reach out to us at SARM, or I think John's even offered to himself, and we can make sure that we get that information clarified. The importance of this is to really make sure that everyone understands fully this new process, as it is going to be a bit of a culture change and a bit of a systems change for everybody, and we just want to make sure that everybody's going into this as eyes wide open as they possibly can. So don't feel like you can't ask questions after this time period as well. So
absolutely, I will second that. I will say, any questions that people reach out to me with, just to make sure that we're making sure the whole audience gets it. Even if I responded back, I would loop in Adam and Brian as well, just to make sure that those questions, that everyone got them. And I sincerely invite everyone, if you have a question in a day or two, don't hesitate to reach out. Because I've given this presentation enough times. I've gotten calls 2-3 weeks later. Frankly, I've gotten calls after people went and met with their board or with their CEO. In your case, a chief administrative officer or a mayor or a council, and they may have questions. You can feel free to route those back. None of this needs to be a secret. What we need, frankly, is everyone to understand prompt payment as best as possible, so that we're all doing our level best to implement it in fair, even-handed ways, and then let the system sort of sort itself out.
Yeah, for sure. Okay, I guess last call for any questions, and if we see none, in the next couple of seconds, we can wrap it up and send everyone on their day. It's supposed to be nice. It's 30 above, I think, here in Regina, so.
All right. Well, thank you very much
John,
for having me, everyone.
Yeah, thanks, John, and thanks, everybody, for attending, and we'll see you at the next seminar, everybody. Thanks again.